If you or your spouse earned a professional degree during your marriage, like a medical degree or law degree, you may ask yourself, can that degree be divided in a divorce? Michigan courts wrestled with that question for decades, and today I want to cover the key cases that explain what will happen in Michigan law with a Michigan divorce. I'm Jim Kraayeveld, founding attorney at Kraayeveld Family Law. I've been practicing for over 30 years. For years, Michigan courts recognized that a professional degree has a value. And on the one hand, some courts ruled that it was a divisible asset, and some courts held that the non-degreed spouse should be compensated for their contributions for obtaining that degree. Now, those two different lines of thinking were finally resolved in the 1991 case of Postema versus Postema. And in the Postema case, the Court of Appeals stated that fairness dictates that a spouse who did not earn an advanced degree can be compensated whenever the advanced degree is the end product of a concerted family effort involving mutual sacrifice and effort by both. As you probably know, Michigan is an equitable relief state, and so the court has to apply equity. In the Postema case, the husband went to law school and the wife put her education on hold. She wanted to become an RN, but at that point she was an LPN, and so she earned a little bit of money during the 3 years while her husband studied and didn't earn much money and contributed with her time doing all of the errands, etc., while he studied. The trial court judge then awarded the wife $32,000 for her contribution. Keep in mind that this was 1991, when the husband's law school student loan debt was only $15,000. The focus of the award is restitution. It gives back to the non-degreed spouse the value of their disproportionate contributions or their sacrifices. So the value of the degree is really irrelevant, and so is its future earning potential. Many cases in the past, parties would try to argue that a degree had a future earnings potential. For example, a PhD in history may have an earning potential of $80,000 to $100,000 per year, while an anesthesiologist has an earning potential maybe exceeding $500,000 or even hitting $1 million per year. So if the non-degreed spouse's sacrifice was the same, they put in the same time, the same financial contributions, the same time raising kids, for example, the restitution would be the same regardless of the earning potential of the degreed spouse. Little side note, there's a case, Wilson v. Wilson, and in which the arbitrator awarded the non-degreed spouse $120,000 of $1,000 a month for 10 years because the husband had taken care of the family and provided the financial support while his wife got her degree. So Michigan courts will base the compensation looking at the sacrifices and contributions, both economic and non-economic. The court has to determine what award would fairly restore those contributions. Awards are treated as property settlements, not as spousal support. That ensures permanence and fairness, because spousal support can be modified, whereas a property settlement cannot be. Another case that Michigan had was Berger v. Berger in 2008, where the husband tried to argue that his wife's master's degree in fine arts, specifically dance, should be valued as a divisible asset. Well, the wife continued to be the primary caregiver to the children. She maintained her employment, and the husband maintained his businesses and didn't change any of his activities and simply tolerated his wife's education. Because real sacrifice is required, either time or money or both, the court rejected the husband's wish to value the master's degree. And these cases all highlight that Postema's principles are consistently applied. Courts are going to focus on the actual sacrifices, not the theoretical future earnings. A little side note that was of interest when reviewing all of these different cases, Michigan law doesn't allow the trial courts to value undergraduate degrees, but they will consider internships, residency, fellowship, etc. following medical school. So, for example, if the medical school was prior to the date of marriage, but the residency or any subsequent time learning or putting more effort towards getting the advanced degree, Michigan will allow for restitution to the non-degreed spouse. Courts have to look at, when deciding the amount of compensation, what is fair. They'll look at the financial support that was paid, tuition, living expenses, who got loans, etc. Were there career sacrifices of the supporting spouse? Like in Postema, the wife delayed her career pursuits. Courts will also look at the non-economic sacrifices, childcare, how much time is putting into childcare, running errands, doing groceries, cleaning the house. If there are moves, for example, if you move from city to city or school to school as a spouse is advancing their career, the stress that it puts onto the family. For example, if a spouse is spending their 80 hours studying or having a little side job or internship plus studying, and that puts a lot of stress on the marriage and on the family, that will be compensated. And as I mentioned earlier, the delayed goals of the non-advanced degree spouse. One thing, though, that impacts the amount of compensation will be the amount of time since the degree was earned. So if the supporting spouse has already been sharing in the benefits of a higher income for 10, 15, 20 years, that is going to reduce the need to be compensated with restitution for all of the sacrifices many years earlier. These are very difficult cases to prove. You have to have evidence. You're going to need testimony of what each party did. You're going to probably need financial records to show what was contributed, who earned what, who paid what. Sometimes there are expert witnesses needed to quantify the lost opportunities or the delayed career paths. Yes, most of these cases are common in divorces involving doctors, lawyers, dentists who are going to end up being higher earners. I want to point out that the practices or businesses, for example, a law office practice or a dental practice, as a business issue, that is even owned by the professional, is also divisible. But that's a different topic than just discussing whether or not the degree has value or that it's a marital asset and divisible. So, some practical points. If you supported a spouse through school and you can document your sacrifices, your contributions, your foregone opportunities, you can support a potential post claim. If you earned the degree, you're going to, of course, focus on showing that the non-degreed spouse's life continued with no change. They had the same earnings, they had the same lifestyle, they had a similar job, and that only the degreed spouse was the one suffering the rigors of law school or med school, and the student loans and the stress and the long hours were all incurred by the advanced degree person. So, another issue is looking at how long it's been since the degree was obtained. Because if the other spouse has been amply compensated with an improved lifestyle over the last 1 or 2 decades, assuming that the divorce isn't right after the completion of the degree, that also negates this restitution Postema claim. So, under Postema, the courts will not consider future earnings. That's an issue for spousal support, that you can look at future earnings, but not for dividing an advanced degree. These claims are complex. They're evidence heavy. They often require expert testimony. And so, yes, legal representation is essential. Hiring someone who has the experience knowing how to handle these cases. In order to ensure fairness for both sides, get an experienced legal counsel. Until next time.